Hi, everybody. Welcome to Health Law Simplified. I'm
Hey,
I'm
Sandy.
Sandy. We've got Elizabeth Lippincott, and today we have some very exciting guests. We have Melissa Newton-Smith and Anna Handshuh, two actual bona fide experts in the highly complicated field of Medicare Advantage star ratings. And I'm going to let them, tell us about the work that they do. But just for our listeners, Melissa is the founder of Newton Smith Group, and has been a business and thought leader in Medicare Advantage for more than a decade, and works with plans all the time to improve star ratings, quality performance, health outcomes. She's also a very savvy LinkedIn user. I highly recommend following her for her posts on star ratings. And then Melissa introduced us to Anna, who is a principal at Cap5 Strategies, a healthcare advisory practice specializing in regulatory and operational compliance, star ratings, quality, basically everything that health plans do, it seems to touch. And as a government programs executive, Anna focuses on creating and implementing all kinds of corporate programs, including relevant to today's discussion, quality and star ratings programs. So we're thrilled to have both of you here with us.
We really are. And I will just add, Melissa and Anna know more about star ratings than anyone else I've crossed paths with. And I've been doing this for a while. So we're very excited that you two took the time to talk with us about this important ruling.
Thanks for having us. We're glad to be here.
So before we dive in to today's subject, which not to tease it any longer, it's going to be the recent Clover Health ruling. But before we get to the court opinion and what it means for our world, I was hoping you could each take some time to tell us how you came to work in healthcare and government programs specifically. It's a very niche world. I think none of us took a direct path here, and we know our listeners love to hear, how we ended up in this role.
Who's going to go first?
I vote you, Anna.
Okay, I'll go first. For me, it was a very accidental way to come about it, like you hear from many people. A friend of mine who was a physician in the emergency room passed away very suddenly right before his 34th birthday, and all his friends around the country who loved him started a clinic for uninsured people in his honor, and I was volunteering at that clinic. And one of our volunteer physicians started a Medicare Advantage plan here in Florida. And he said to me, stop wasting time in nonprofit and come do this very exciting thing called Medicare Advantage. I couldn't even spell CMS back then, but I was handed immediately chapters 2 and 3 of the Medicare Managed Care Manual, and I was off to the races. And that was a little bit over 20 years ago.
Wow. What a great story.
Very powerful.
Yeah, mine pales in comparison to Anna. I should have gone first, Anna. I should have been smarter than that, because mine is so much more boring than Anna's story. But much like Anna, I came to Medicare Advantage completely accidentally. My hidden talent is I'm actually, like you guys are lawyers, I'm actually a CPA. And I had been in public practice, both in the big six at the time for a while, and in an academic medical center working full time. And I had decided that I wanted to cut back to a part-time role while my kids were little. And much like Anna, I just had an accidental interaction with a former colleague from my public practicing days who said, I've got a job. I'd let you go part-time to work for us. It's something called Medicare Advantage Part D. I did not know what Medicare Advantage was. I certainly did not know what Part D was or what the job was. But his commitment to me was that if I would give him everything, he would let me put my kids on the bus every day, and he would kick me out of the office every day at 2:30 so that I could get them back off the bus. And my job was
Good deal.
So, I just showed up. I showed up. I didn't know the words. I didn't know the business. I had no idea that 20 years later I would stay in the business and love the business, or I should say it kind of found me. And I just happened to have kind of meandered around, much like Anna, into a niche that I understand, I love, I'm passionate about, and I no longer do it from 9 to 2, but it really was
Clearly,
That's
we
right.
know
It's a
that.
remarkable way to, I call it my part-time mom job that really turned into something remarkably late career. That's a fun story to tell. And I'm ever grateful for the folks who let me do that work at the time in a health plan here in Nashville. I tell them that all the time. My gratitude runs both deep and wide.
That's wonderful. And I love being surrounded by quantitatively gifted people. So not only Melissa with your CPA background, but Sandy was a dual math and English major and is just very facile with numbers. And so, yeah, great.
Yeah,
Love it.
that's also a very human story, Melissa. And I really appreciate hearing it. And it just makes me reflect on how the learning curve for this industry is quite steep because there is so much jargon, especially when you're talking about star ratings. And it makes it a really worthwhile investment. So, we are so lucky that you all have stayed in the industry for as long as you have. And it's gone through so many changes, continues to be extremely dynamic. And I know that, it's not just us, but all of your clients that really benefit from that investment. So we are going to talk about the Clover ruling. This was a case that Melissa and Anna, you brought to our attention faster than anybody. You beat all the news outlets on this very major case. I frankly am still surprised that the press coverage has not been as significant as I would expect for a ruling of this impact. I'm just going to give a really high level summary for people who aren't as familiar with it. So it is a federal district court decision in a case that was brought by Clover Insurance Company, a MA plan, against the Department of Health and Human Services about their star ratings. So Clover challenged its 2026 MA star rating after it dropped from 4 stars the previous year to 3.5 stars. And that drop in stars correlates to about $120 million in bonus payments. So very, significant financial impact, a good reason to challenge the government's methodology if you think they may have made a mistake in how they calculated those star ratings. As we've alluded to, it's a very technical process. So plans are very incentivized to get in the weeds and understand if it was done correctly. So at its core, this case is about a really simple question that has big impacts, and that is, what data is CMS allowed to use when it calculates star ratings for a plan? And the court ruling, I believe it was a 72-page ruling around there. The court came down in a way that is potentially very disruptive. It held that star ratings have to be based on traditional HEDIS, HOS, and CAPS data collected through plan quality programs. And we'll get into this, but what that means is that a number of measures that plans rely on every day that come from other data sources, things like medication adherence, call center performance, et cetera, all of those are called into question because they are based on other data sources. And the court also said that because star ratings directly affect payment to plans, all of these measures should have gone through what's called formal notice and comment rulemaking. So we'll get into that as well. And that is a pretty significant procedural check on CMS. And as a result, the court said CMS relied on all these measures that it shouldn't have. We are vacating the star rating, that 3.5 star rating. We're sending it back to CMS, recalculate everything for Clover Health with measures that you're actually allowed to use. And that's what CMS did. They did, and I'll let you all tell us what CMS did after they decided to recalculate Clover Health star rating. And yeah, that was the ruling. So the ruling's about one plan, Clover Health. But we think it raises a lot of bigger questions about the structure of the star ratings program and how stable those rules are going forward. And I'm hoping that's what we can unpack today. So turning to Melissa and Anna, what was your initial reaction to that Clover ruling?
All right, Melissa, you want to go first this time?
I was going to say, you know what? I'll go first, but I shouldn't because Anna actually found the suit and sent it to me. So of the four of us, Anna's actually the early genesis of the document. You know, I'll be really honest. I was absolutely astonished with the ruling. One, as a person who follows all things MA and star ratings closely, I had not even paid that much due diligence or attention to the case itself when it was filed, because there have been so many cases as we've seen, you know, Scan and Elevance. We've seen all the nationals have filed star rating suits. We've seen just this proliferation of legal challenges to various aspects of the star ratings. So when this one was filed in November, not being a legal expert, but more of an operator, it just sort of was something I dismissed as a bit of a lark and did not pay it much attention at all with a somber seriousness that it warrants. So my initial reaction was absolute shock. And I'm still a little bit shocked. You know, we've been sitting on this a couple of weeks. It's one thing to restate the facts in a thoughtful, professional fashion. But I am still very shocked with the ruling and certainly think it's far from over. But I don't know, Anna, maybe I'm feeling a little dramatic this afternoon. Maybe my shock and awe is not shared by other operators of expertise in the space. What do you think? What was your reaction?
No, look, my first reaction was, wow, the headline on this and the holding, you know, really what the ruling was are really two very different stories, right? The headline is Plan beats CMS on star ratings, right? We still see similar headlines even a couple of days ago that says Plan beats CMS. But when you actually read the ruling, the reasoning behind it is a lot more seismic than than what is it, dog bites man or man bites dog or whatever we want to call it. What really surprised me wasn't that measures got challenged. That happens all the time, right? That's been happening the last few years. Plans have been more willing to go to court to get relief over the last few years. What was really surprising for me was that the court went after the plumbing, not the window dressing, right? The statutory authority for the data itself and whether the technical notes should have gone through formal rulemaking. That's a structural argument, not a we don't like the cut point argument. It's more, it's much more far-reaching.
I share both of your reactions. Melissa, when you sent us over a question about the case, and I put it on my to-do list to look at, expecting it to be another one of the same, somebody challenging some call center calls that they contend should not have been included, small potatoes. And as I turned to the opinion, the more I read, the more my jaw hung open, and the more I was messaging Elizabeth on Teams saying, I can't believe what they're doing. They're calling into question the entire methodology that CMS uses. I don't know if you have any color to add, Elizabeth.
Yeah. And we're going to talk, about potential implications, although this order only governs Clover's 2026 rating. The holdings in the case could have implications for every plan going back years. And so it was a bold decision on the part of this federal trial court. And we'll have to see how it shakes out. But the potential implications are significant across the board.
I think that's, Elizabeth, as I listen to you and Sandy describe your legal perspective on this to us as operators, I think that's been the most surprising aspect of this. Is there is still this interesting perception that it's just one more operational challenge that was won by one plan, and the seismic nature of maybe up to 6 open payment years, 9 star ratings years, the entirety of QBP and rebates, and the swings this could have had looking backwards, I think has maybe not gotten near as much attention in the last couple of weeks as we thought it would. Again, like Anna and I kind of raced to the punchline. We're kind of students of what is this, at the same time we're students of what does it mean once we know what it is. And I think we're still not seeing anywhere near enough intentional, thoughtful examination of the length of time and the financial magnitude of what this calls into question beyond just what might they do in the short run with 2027 bids for others, not just Clover. Anna, do you share that same perspective?
Yeah, I would say, it's significant with an asterisk to it, right? Because, as it stands today, like all of you have just mentioned, it's one plan, one contract, 1 year, Clover, right? It's not a nationwide ruling. So in the literal sense, this is a small incremental type move, but what makes it really disruptive is this reasoning behind it, right? That the court didn't just say, oh, CMS scored Clover wrong. It said the legal foundation under the whole category of measures is shaky. And that type of logic is not something that can, by its very nature, that just can't stay in that box, right? Because they've got to be, they can't be arbitrary and capricious, because that would be what's next, right? If the next plan comes and doesn't get the same treatment, then it would be arbitrary and capricious. So other plans could immediately read that logic and think, well, could I make that same argument? So I think that's why this is so, the implications are so much bigger than what we originally think. And I think that's kind of why we're sometimes surprised. Although there's a lot of chatter, not a lot of substantive, like, okay, what should I be doing right now?
I suspect that sort of the reticence in terms of legal analysis to say, oh, okay, this is what this is going to mean, is it's so contingent on what happens on appeal, even at the 11th Circuit level, this is federal court in Georgia, so it'll go to the 11th Circuit. I think we're all just kind of agog at the scope of the ruling, and it's so bold that I really want to see. I think we need to parse that out now and think carefully as we are today. But I think that we all need to see what the appellate court does with this when, assuming it gets to them, and I'm almost certain it will.
Those are really excellent points. Just for those who are interested in the timing, HHS has 60 days from the date of the judgment to file an appeal. So that will be due July 28th, I believe, which is 60 days from the date of the motion for reconsideration that it ruled on. We can talk about that a little bit later. And not only is there a question mark around what the 11th Circuit is going to do, but the way that the federal court system works is, if another plan files a lawsuit in another federal district and another judge is looking at these same statutory provisions, they could come to a completely different conclusion. And so we could be in a situation where we end up with a circuit split, conflicting opinions, and ultimately it has to be resolved by the Supreme Court. That's very premature. We're not there yet. But to the point that you've made, Anna, the court's reasoning applies to every single plan because it's not about facts that are unique to Clover. And so this case really does give a blueprint to every other MA plan that is unhappy with their star rating in 2026 to challenge CMS's conclusions and the amount of their quality bonus payment. So I am surprised, frankly, even with the need to wait and see that there hasn't been a bit more activity, in terms of plans running to court, but they have time.
Yeah. And note that Clover cherry picked the measures that it didn't like. So even measures that would have been out under the same logic, that it picked the measures it didn't like, right? So like it picked one appeals measure for removal, but not the other one, even though they would have been out under the same logic. So plans really, as they're modeling, like, hey, what would my position be? They could do the same thing, right? Plans could say, well, if Clover got to cherry pick the ones they didn't like and leave others, right? Because the court's going to rule only on the measures that are in front of it, not on things that are not in front of it, right? So they could pick the ones they didn't particularly perform well on as well.
I want to ask a clarifying question just to make sure that people appreciate this. So when I first read the ruling, my takeaway was the court threw out 20 measures for various reasons and said those should not have been included. But what you're saying, Anna, is that the ruling is not limited or would not be limited to those 20 measures, or the court's reasoning would apply to any measure potentially that a plan wanted to challenge. Is that correct?
Yes. So the ruling did apply only to those 20 because those are the 20 that Clover put in front of the court to consider. But the logic, right, like the logic beyond, underpinning those two holdings, there are many more measures that are affected by that logic, right? So all the Part D would be affected, right? If we think about it. And really, if you look at the second holding around, you didn't go through comment or notice and comment rulemaking, that would be all of them, right?
Literally every single measure.
So if, in other words, Clover just picked the 10 that it didn't, that would bring them over the finish line successfully, other plans could really try their hand at doing the exact same thing with a different set of measures that would meet that criteria or that would follow that same logic.
I think if I were in the government shoes in that scenario, I would think about counterclaiming. If there were other measures, if a plan truly just cherry picked the ones where they didn't do well, I wonder if you could have sort of if the court rules against that, then our recalculation needs to take into account these measures where they did perform well, and we no longer can take it into account. Or,
Sure.
it gets really complicated if they truly are just cherry picking the ones that would push them over the edge and not ones where they did well, where they need it.
Right. Don't forget, Judge Woods didn't say to CMS, you have to give this star rating, or they just said recalculate consistent with this order. So they could have recalculated really truly consistent with the order and said, well, we don't have enough measures to give you a star rating.
Well, and I think we get a little bit more complicated because I can't remember, Sandy, whether it was you or Elizabeth that mentioned this. We've not seen a race to the courthouse. I think a couple of us wondered if we might see a race to the courthouse really efficiently. But every contract is going to have a slightly different subset of measures that they would like removed from their own contract's rating. So you can imagine, and not all of them can go to Judge Woods in the 11th Circuit. So if other plans that do have urgent reasons to file a similar suit and hope for similar type of relief, but on different measure sets, you can see how it could be in very short order among that small group of plans who do show up and file rapidly for good, valid reasons. We might wind up with various different mixtures of measures that different courts are asked to provide relief for, and an extremely varied interpretation of how to apply this just among the suits that are filed. Because, I mean, frankly, we will see some suits filed. If we don't see suits filed between now and the date CMS appeals, we can't forget that in the first week of August, we're in the next plan preview season. We have a whole fresh set of ratings that will be subjected and applied to this. We will see more suits between now and, say, mid-October.
And we have seen at least 2 plans already take this decision and give it as and file this decision as support for their own cases that are currently pending, Humana being one of them, of course.
Let me ask you a technical question. If you assume this ruling gets upheld all the way through the court system, assume this becomes clearly binding law nationwide, does it leave, looking back historically, does it leave enough measures intact for there to be valid star rating decisions to be recalculated?
I think it depends on the first and the second bucket. Let's start with what Anna just described a moment ago. If the court's ruling about the quote second batch of 10 measures that weren't subjected, the specifications of the measure itself were not subject to notice and comment rulemaking, there's not enough measures left to have a star ratings program if that holds. So the second one's a different problem than if the first batch of 10 holds. If the first batch of 10 holds and CMS is forced to use only Part C measures that meet the definition of essentially HEDIS, HOS, and CAPS, there will be plenty of measures to assign a Part C rating. Mm-hmm. But again, back to the Clover anomaly that we opened up with, we're still in that weird situation where if the Part D measures are removed from the program and if CMS follows the technical specifications as they stand today, there is not a Part D summary rating and thus no overall rating, which changes the entire bid implications and rebate payments. So it kind of portends, Sandy, a little bit to what I think you alluded to, that no doubt we're going to see this escalated, because even if the first holding holds and there's technically enough measures for a Part C summary rating, the inability to calculate an overall rating and administer the remainder of the quality bonus payment infrastructure is left in the mix without clarity.
I'm going to go out on a limb. Because I actually clerked way back in the day. I clerked for the 11th Circuit. I predict, this is worth what you pay for it, but I predict that if the government's attorneys make those implications clear and convince the courts that upholding this ruling on that second set of the second part of the holding about the notice and comment that would basically invalidate star ratings going back historically and forward for, half of the plans that cover half of the people in Medicare, I don't think they're going to want to do that.
But don't forget, Elizabeth, they can cure that, right? Just put it through notice and comment rulemaking. Just do it.
But retroactively.
They can't do it retroactively, right?
They can't do it retroactively. I don't think they're going to want to do that. That is so destabilizing.
I'll play devil's advocate.
I will be surprised if they
I'll play devil's advocate.
Please do.
This whole decision is about statutory interpretation and revisiting what the Social Security Act says that CMS can do with data in its possession and how it can pay plans. This decision is, I think it really highlights how different that interpretation is in a post-Chevron world. There's no, we never seen a decision like this because CMS was granted discretion or, afforded discretion to interpret these statutes. And the courts are saying, no, we are in charge of interpreting the statutes. And CMS has gone wild in terms of the amount of data it's collecting from plans and what it says plans have to do. And it's changing the rules for star ratings calculations every single year. We've talked about at length how this has destabilized the industry in so many ways. There's so much payment uncertainty. I think there's a really strong argument that the check on CMS authority is appropriate. And the judges might be inclined to hold on to that power to interpret.
So I'm thinking, sorry, none of us prepared for these questions, because I'm just coming up with them on the fly. But so Loper Bright was a recent decision. This ruling is about 2026. I'm just wondering if they are going to want to do anything, or if other cases are filed. I think they'll be really reluctant to want to make a decision that requires recalculation going back.
Yeah, I
many
would
years.
agree.
That seems too nuclear to me. But I do agree with you that like 2026 would be doable.
You know, as we were talking about yesterday when we were discussing this case, and I showed you the preamble language to the final rule where star ratings is, finally codified, and they go through this whole mental process. CMS is explaining, like, here's how we're going to do it, and this is where we're going to make the announcements, and this is where we're going to announce the star ratings every year, which ones they are and which ones count, and this is where we're going to put the technical notes. And they actually have that conversation in the preamble, and we see their thought process, and we see CMS saying, and we're not going to put that through rulemaking because we don't think that's required, right? So we see that they made that calculation. They actually thought about it. And, I think that statement might have been more like, because we don't have the resources to literally do this in advance ahead of time and publish those things and think about it, because that's where the cut points are, and the cut points are not prospective, right? As they're based on once all the data is in. So there would have to be a different mechanism for publishing the cut points rather than where they're published today. So, you could see that they actually thought about it and made a judgment call and made a decision. It wasn't just like, we're going to hide this from plans until the last minute. It was a deliberate thinking and conscious decision-making process they made.
Yeah.
Just the judge didn't agree. And as a matter of fact, Judge Wood said, if you don't like it, take it up with Congress.
So, and I think that is one challenge here, is that the cure, it would be very difficult for CMS to cure these deficiencies on its own, particularly if it wants to include the Part D measures, right? That would require an act of Congress.
Or, let's keep kind of playing devil's advocate. So, Sandy, just like you played devil's advocate for a second on the
please, I welcome it.
Topic. It's also important to remember that on the Part D measure side, so much has happened in sort of off book, out of the CFR territory from the time that those 2003 verbiage was inserted into the CFRs and that initial Part C references to HEDIS, HAS, and CAPS were made. Just think about what we've seen in the Part D space that has happened since those words were entered into the CFRs. We had Part D measures come out of the demonstration. We have star ratings as we know it go into a demonstration project with all that entails, and come out of the demonstration project through the totality of the ACA debate, rulemaking, codification, implementation. I still am not personally 100% convinced that perhaps the evidence we're looking for is maybe sitting somewhere in the old CMMI annals, perhaps somewhere in documented evidence in the ACA process or the demonstration process. It would be stuff that until now we would never have gone looking for. It wouldn't have been something that somebody would have said, oh, that's not in that CFR, let me go find it. Kind of like the missing Tukey sentence. That missing Tukey sentence existed somewhere. It just got left out. The one sentence got left out of the CFR. I'm just not 100% convinced we know yet with confidence whether perhaps all of that first holding about the data sources might be solved somewhere else, and we just might not have seen it get to the CFR because we didn't pay enough attention back then to the verbiage in the same way we do now, for the same reasons we do now.
That's really interesting. And I think it's also important that this is an application of Loper-Bright. This isn't just what CMS does in this space, isn't just regulation of a private industry like fisheries, or these are government contracts administering over 50% of the Medicare benefits. And so it is a little bit of a different context and we're talking about the way the government pays those contractors. So it is distinct from other regulatory environments. And I think that gets lost
I
a lot.
You're right. The other thing that I think is getting lost in this conversation of like, what would CMS do to go backwards or forwards, is the reality that within Medicare Advantage, the financial construct after the revenues are awarded, they're almost all spent. At least 85% has to go out the door or back to CMS. So if we think about this, it's gone.
It's gone.
It's
It's
gone
gone.
in
The
chaos.
money's
So
gone.
this concept of
Yeah.
would
Yeah.
CMS come forward and give some sort of quote better of relief? Where would it go? Would it all go 85% to all the docs that were?
Oh, that's
Where
a
would it
great
come from?
point. Would it push people out of their MLR? Would they have to?
Yeah.
Oh my
So
gosh.
I don't know. Like
Yeah.
this, again, this sort of doomsday. Somebody accused me of being a doomsday person, so I'm going to share this with the full transparency that maybe it is a bit of a doomsday. If they were to really be held liable going backwards the full 6 years of open contracts, no matter what the sense is, it's starting to feel like of the ilk of like the 80s SNL crisis, because the size and the breadth and the complexities of funds flow is of that nature, since it's not just cash sitting in someone's bank account or to go into somebody's bank account. It's just hard to even fathom how a cumulative retroactive payment would be collected or paid out, frankly. We might have to figure it out.
And even who would calculate it? How would they find the people who would know how to do those calculations?
I'm a CPA and Anna's a compliance person. We're all about procedures and processes. I assure you we could figure out what the dollars to be paid or collected would be. The question then starts to become, if you guys think on the legal side, think about unrecorded liabilities and uncollected property. It starts to be, where would you go? Because so many entities in this volatile last 6-7 years have gone out of business, sold and shuttered at a markdown. It's the practicalities outweigh the calculations, I think. But I think we could do the calculations.
Contracts, those types of things. Yeah.
Melissa,
we were on the phone with a California plan earlier today. And again, every state's going to be a little different. Every payer-provider relationship's a little different. I think it's been also a little bit surprising that we in the payer space have had this depth of conversation and are having this dialogue today in a rich, educated, thoughtful manner after having had time to process it. Think about like the state of California. If CMS were to go backwards, every provider in the state operates under a delegated payment arrangement. So I'm kind of curious how long it takes for some ambulance chasing attorneys. Not that there are such things as ambulance chasing attorneys. I'm sure we're going to see some attorneys kind of stir up and spin up. But you can imagine there will be claims of a magnitude from those folks under percent of premium or capitation or delegation, wanting how they might have been part of this as well. I think in pretty short order.
Yeah, there are many more stakeholders here than just plans, right? We have the entire pharma industry that relies on those Part D measures, right? All of it. They're not going to go quietly into that good night. Oh, sure, no problem. Right?
I have to say, I think your doomsday approach, Melissa, is offset by your optimism that these questions are all answerable, right? The experts exist in all of these fields, and these questions can be answered. And I think our clients, all of our clients and listeners are wondering, what does this mean practically for us? Like, what should we be thinking about as we wait for CMS to make a decision, or as we wait for this to work its way through the courts? I was wondering if you could just speak to and give us a little bit of insight into how the excluded measures, let's start with the Part D measures, the measures that don't come from HEDIS, HOS, and CAPS, assuming that part of the opinion is upheld and applied across the board. How big of a shift is that for plans? How central are the excluded measures to current STAR strategy, and what will plans need to do to address a change of that nature?
I think very central. They're very central, right? Like medication adherence alone, the 3 Part D adherence measures have been some of the most heavily managed, highest weighted real estate in the entire program forever, right? For a decade. Plans have built whole pharmacy and member outreach operations around it. And also think about those measures also drive success in the clinical outcome measures, right? Because they're connected to good clinical management of diabetes and heart disease. From a call center appeals, complaints, those touch operations every single day. When you hear, like 10 measures excluded, understand that, for Clover's calculation, those weren't fringe measures. They were like load bearing walls, at least in most stars strategies they're not fringe measures, right? They're not little measures.
The only thing I might add, the only
And they're
the only context I
embedded
might add to
yeah.
that, though, is there are a lot of plans that have treated this work in a measurementship standpoint. So as Anna said, big investments needed to be invested in for stars real estate for a good reason to get the contract math to where it needed to be. But we've got lots of plans that have just simply built those quote programs in service of measure numerator tracing versus actual hardwiring of real medication management programs and material meaningful work. And I think this is kind of forcing that conversation of, is what you're doing just chasing measure numerators for today's measures, or would you be doing that same work in that same way if the measures went away? Which folks like Anna and I are always asking. We're always in front of people saying, is this what you would really be doing if it wasn't a star measure unlocking quality bonuses? Or is this work you're doing so narrowly defined and spent just to get the stars real estate? I think we're forcing that question with speed and urgency in a way I think few expected to be asked that question this particular summer. But the measures themselves have been core to STAR strategy. I'm not sure, Sandy, to your question, I'm not sure the core hard work was super hardwired into most organizational clinical strategies beyond how do I get to my QBP or get to my rebates in many cases.
And remember, call center appeals, complaints, all of those were going anyway, right? 2027 final rule came. I wonder if CMS was already predicting that this had a possibility of happening, right? This case was there as they were putting out 2027 final rule. So, those measures, and CMS has been talking for a long time about giving a different focus to star ratings measures that was more clinical and outcome based than these call center appeals complaints measures would be able to assess performance on. So these are not as big a deal other than the fact that they're, higher weighted measures that take up a good chunk of real estate within a health plan's portfolio of measures. And also plans tend to do well on these measures. So as they go away, perhaps prematurely, that's something to think about.
Another practical implication that concerns me is this ruling comes on the heels of the 2027 final rule, which was already making significant enough to be disruptive to operations and strategy changes to star ratings measures. And advising small and mid-sized plans, some of which are struggling with profitability, have boards that are, how long till it takes us to get to profitability? Or, do we want to keep staying in this? I think it really fuels that fire of uncertainty and potentially makes this, and even though here, we're not talking about risk adjustment data validation audits going back to 2018. This might be a good thing, but even so, it's just like chaos. If you don't know how much you're getting paid going forward, looking back, what's happening. I worry about the impact on decision makers about, how much of a priority do they want Medicare plans to be in their product portfolio?
Yeah, I worry on that same front too. I worry about two different types of Medicare plan leaders in particular. I worry about the Medicare Advantage plan leaders that were intentionally brought from the outside by well-intentioned hiring executives and boards that wanted non-healthcare experts or non-insurance experts. They intentionally wanted disruptors from other industries to sit in their mature MA, stable office and do different things in MA. I worry that that group of leaders is probably going to need more help, not less, to weather this, because they're new to the industry. And as we're talking today, there's a lot of deep technicalities that we're comfortable with that they'll be learning on the fly with high pressure. I worry about those guys. The other folks I really worry about is our group of mid-level leaders that have only ever known mature STARS programs that someone else designed, and that they've operated with very little program changes and a lot of a landing pad underneath their high wire. Those folks that have never had to stand on the high wire and cross the crevasse with nothing underneath them to catch them. I think this is going to be an interesting test for folks that have only ever known how to run stuff somebody else built and keep the train on the tracks versus set the compass, turn the train on, and steer the plane. Definitely, I think, a bigger challenge for our small and regional plans, except for the fact, okay, Sandy, I'm like my eternal optimist here. It is a blessing and a curse what I'm about to do here, except for the fact that these changes are made for small and regional plans. Because if we get rid of all this noise, we are left with caps as a measure of access to appointments in care that small and regional plans do best. If we do the right care in the right setting, it's risk adjusted properly, we have short-term profits, we're stemming off expensive events, and then STARS happens naturally, instead of why I think we're having this conversation today, because right now STARS is such a non-natural project off to the side. And this is really forcing the asking of that question of what are you doing and why are you doing it in the order and with the focus you're doing it in? And is that the right way to think about quality with a small q or a big Q in Medicare Advantage? Or is this your moment to right size your focus on quality?
Thank you for bringing that up, that this could be a disruption that's uncomfortable in the short term, but leads to something better for the competitive.
For sure. And again, I want to go back. Like, CAPS has always been an afterthought, because these measures that we're talking about going away could always make a list. We could easily track progress and hand-to-hand combat or block and tackle our way up to strong performance. When we take that out and we're left with CAPS as a forethought, not an afterthought, Anna and I say this all the time, your best path is great care orchestrated for every person to get your risk adjustment first, your STARS second. And CMS, Chris Klump has been on his speaking tour this spring. He's told every plan that's your only way to succeed in Medicare Advantage. So again, I do think that this is going to be great for the people that embrace change, move first and move fastest with new and emerging technologies, instead of play games with yesterday's vendors, yesterday's lists, and yesterday's measures. But I think time's going to tell who's interested in standing up and taking that sort of leading edge space. I don't think we know that quite yet. I think everyone's still trying to figure out, do I have an active lawsuit versus am I going to embrace this and do something with it? What do you think, Anna? We've been trying to collect as many perspectives as we could.
I keep going back to what you and I always say to plans when we're there talking with them about what to do. And bottom line is, connect members with the care they need when they need it, medications they need when they need them, and information they need when they need them. Though that's what's left, right? So if everything goes away, HEDIS, CAPS, and HAWS is what's left. And what I just said is HEDIS, CAPS, and HAWS, right? If you do those things, everything else follows from there. So I would say, those basic things like plans, like, oh, what do I do now? I'm going to make a decision whether I'm going to invest this or that. If it does one of those three things, preferably all three of the things at once, that's what you want to invest in. Continue to invest in. Don't throw out the playbook, right?
Yeah. And you don't have to trust us. We could tell you stories all day long about why this is true and why this is worth relying on. The data tells, Elizabeth, just like you said at the beginning, the data tells the story. When we look historically at the plans that have most naturally and sustainably earned 4.5 and 5-star ratings with the least amount of measure games or measure spending, it has always been the best special needs plans in the nation who orchestrated proper care journeys for all their members. They were properly risk adjusted, which generated profits. And some of them never even thought about a star measure and became 4.5 and 5-star plans. So I think if we take nothing away from this, this is not than Anna just,
Yeah.
telling you a story and hoping you believe us. But go back and look. The best 100% special needs plans have always done this work through appropriately shepherded care journeys that just naturally produce star success efficiently. So we got a lot we can work with here if we'll just.
Yeah, that's a great perspective. And it also dovetails with the enrollment growth, over 80% of it this past year being in special needs plans. That is a great point.
So understanding that it's a long journey to, to providing that quality of care. If you're advising a plan today, they're like, what do I need to have done yesterday in response to this ruling? What are, 2 or 3 actions that you would advise either to leadership or to a star ratings team in sizing up their response to this ruling?
You want to go first, Anna, or you want me to go first?
You go first.
Okay. One, that's a very hard question, because anytime somebody says, what are your 1, 2, 3 things? I'm like, oh no, I've got like 20 things. So it's a personal problem. I will try my best to stick with 2 or 3 things. So the first thing that I would tell plans is to stop expecting an immediate answer. We've got people waking up every day and pushing the refresh button on HPMS to see, did CMS give me something today? Did CMS give me something today? So my answer has been what you guys said earlier. CMS has until the end of July to file an appeal. It feels certain they will. This is going to be protracted. So bracing people that we're going to have to build a plane and fly a different plane is going to require 2 pilots, if you will, in that analogy. So slow down and stop expecting immediacy on this is my first thing. My second piece of advice to MA plans, not just STARS teams, is to stop thinking about this or avoid the temptation of thinking about this as something the STARS team can tackle for you, or that the STARS team would even know how to posit an appropriate organizational legal strategy. This is really a board, CFO, CEO perspective of where do I want to spend my political capital? Where do I want to spend my budget on legal fees? Do I have something I need to shape? Do I have a policy need? Do I need to be along for the ride? But most STARS teams can only be an informer in the RACI structure versus all of the RACIs on this. So the STARS team showing up with information to educate and support versus the STARS team saying, sue or don't sue, or I have all the answers and I'm your gatekeeper no matter what the topic is. This is the time for the STARS lead to be a team player in a really supportive role, escalating and raising the topic versus trying to pretend like they have an answer that's going to be appropriate for the legal structure. And then
it sounds like alongside the in-house
yeah.
counsel and the general 100%.
Counsel I would never be able to
making strategic predictions.
And then my third recommendation, I will keep it to 3. My third recommendation has been, this is the moment to take a hard look at your STARS work plan. Almost every plan we've worked with in the last 2, 3, 4 years has started a project by saying, I don't really trust this work plan. I don't like this work plan. And I wish I could throw this work plan away. And that's because these work plans are loaded up with a decade of measure level baggage that we can now see. CMS can pick and choose measures to pitch out of the program in a flash. So my advice is look at your work plan with extreme objectivity. And if you are spending time or money on anything that is one measure or one type of measure, think twice, because every measure has a connection to quality, a connection to access, a connection to experience. And if you're spending money in this environment, you need to make sure you're getting something more than just a numerator hit or an exclusion, because all of that might be obsolete before you have time to be paid on those narrow single purpose interventions. So it's just a really great time, in my opinion, to clean up work plans and evolve with speed, which will make folks ready for 1/1 of 27. Okay, Anna, I did my best on 3. I'm not really known for keeping it to 3. What was your 3B?
Well, I think that's a really good point, though, that I want to just kind of dive a little deeper, Melissa. It's kind of like ask yourself, like, if this wasn't a star rating measure, would I still be doing this activity? Does it have value? Does it drive, does it bring on its coattails? Does it bring other experience, quality, clinical value, total cost of care value, getting accurate risk adjustment value? What does it do? If it wasn't a star rating measure, would I still be doing this activity? If the answer is no, think twice. Okay, so 3 things, maybe 5 things. I'll stick to 5 things. One,
Go for it.
run these calculations. If you haven't run these calculations, model your rating with flagged measures removed. So do Clover's, but also do the ones that you would want out, so you know what your upside is. That cold, you know that number before someone asks you for that number, and quantify the dollars, right? Translate, what does a potential half-star move into actual bonus and rebate impact for the finance team? So make sure you know that, again, before someone comes calling for that number. Get legal reading the opinion now. I'm sure your legal has read it, but don't wait. Make sure that any of your own measures sit in that same shaky ground that, which ones do you want out? Which ones would you want? So know your numbers. That would be like, I don't know, that's a couple things, but we're not counting. Right away, I would want those scenario models to be kind of systematized, mechanicatized, not being one-offs. So build tools so that you could be running these models as the math on the ground or the situation on the ground is changing. So do, what is your base case? Where do you sit today? And then if these things move, what could happen? But have a tool ready for various years so that you could do that. And then I really want them tightening those partnerships with finance, compliance, legal. They're never at the same table, we find. And I think that's such an important thing right now for them to be tied at the hip. And I would say like a really important thing is just resist the urge right now to like tear up the current year playbook. Don't tear it up, right? Like the discipline is going to be add the new analysis, without subtracting from the good work that's paying the bills right now, but just make sure that you're ready to pivot if you need to. So I think those are my, however many things those were.
3. Anna, it was 3. Good job. I call it 3.
All right. You
I like
are
it.
brilliant.
I like the way
both
you
of you. Thank you so much. I feel like I have probably got 20 more questions that I could ask you, and I'm not going to because we've been going for an hour. Elizabeth, do you have any final closing questions or thoughts?
I'll come back to the uncertainty, and I'm just really empathizing with health plan business leaders right now, because this is a tough way to work in this program. With this level of uncertainty going forward and looking backward between RADB and the STARS ruling of how much money did we make? How much money are we going to make this year? Like, what do we have to work with? What are our premiums going to be? That's tough.
It really is. Any final thoughts from Melissa or Anna?
No, other than, our industry, like we're doing here today, our industry is full of a lot of really smart, really talented people that are both professional thought partners and therapists in our spare time. To Elizabeth's point, I do feel like that I would like to leave people with a moment of optimism that if you're not feeling strong or confident inside of your own plan, there's a lot of professional circles that you can get connected to for more collaboration, more learning alongside other parties that are getting through this together. It's harder to remember when you're stuck in your own home office and the feelings are overwhelming, but there are some really great learning communities and professional societies that I would say are underutilized at the moment, and probably just have a great moment in the sun as we go through this time together with a lot of confidence building and growth.
I think we know what's going to be the hot topic at all the conferences next year.
Next year, there's one coming up at the end of June.
Yeah, excellent, right.
The Rise Quality Conference, yeah.
Are you all speaking there?
We are. You can catch us there, and we'll be talking about this.
Terrific.
Great.
We will include that information in our when we put this podcast out. Thank you so much for joining us. It's been a real pleasure.
Thanks for having me.
Yeah, this was fun. Thank you.
Thank you.